Hi, good night everyone. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to answer your U.S. immigration related questions. So go ahead and put your questions in the comments so that I may answer your questions. So let me formally introduce myself. I am U.S. Immigration Attorney Sharifa Tharpe. I help clients to get their green card and status in the United States. I'm also here every night at 9 p.m. to answer your U.S. immigration related questions, with very few exceptions, of course. So I encourage you, put your questions in the comments. It can be anything that's immigration related. I usually come with a topic to talk about. And so tonight I'm going to be talking about the consular processing. What does that process look like? And I'm also going to touch on waivers. So that is if you've overstayed and you don't qualify for adjustment of status, what the alternative would be the waiver in order to get forgiveness for the overstay, to leave and attend your final interview at the embassy. So anybody who qualifies for permanent residence can do it through consular processing. That means that you will attend the final interview at the embassy in your home country. Now, go ahead, put your questions in the comments. It doesn't have to be related to what I'm talking about. So, and feel free to put your questions in as I'm talking. You don't have to worry about interrupting. Now, when you apply, the first thing when you're going through consular processing is that the employer, if an employer is applying for you, or your relative, your qualifying relative, will submit a petition here in the United States. And the petition gets processed first. And once it's approved, doesn't mean that you're just going to get the permanent residence. What it then means is that the approved petition is going to be sent to the National Visa Center. At the National Visa Center, the National Visa Center is going to review to see if it's ready for processing. That is where the process can take the longest. And many individuals think that when the petition is approved, that means they get the interview right away and they're going to get permanent residence. Unfortunately, that is not the case. So it really depends on what category you're in, meaning who's sponsoring you, what's your marital status, what's your age, and are you the son or daughter or the spouse? So I'm going to break that down for you. So first, are you the immediate relative of a U.S. citizen? If you're the immediate relative of the U.S. citizen, that means your process is going to take the shortest time. It is the fastest way to get permanent residence. Immediate relatives of U.S. citizens are not all relatives of a U.S. citizen. It's only a limited group. And so this is down to the spouse of a U.S. citizen, the parent of a U.S. citizen who is 21 and up. So let me stop for a minute. In order to qualify for permanent residence, to get status, your U.S. citizen son or daughter has to be 21 or up. So if you have a child that's younger, a young child, that will not automatically qualify you for permanent residence. That child has to get to 21, and then that child has to apply for you, petition for you to become a permanent resident. Now, of course, there are some exceptions. So if you do have a child who's 21 and up and they're mistreating you, there is the VAWA process. Of course, that will be for a different night, but I just wanted to let you know that there are exceptions here. Now, and of course, you usually have to be in the United States to qualify for that. Now, the other immediate relative of a U.S. citizen is going to be the son or daughter of a U.S. citizen who is under 21 and unmarried. If you don't fall within this category, then it's likely your process is going to take a little longer. And so if you're, for example, the U.S. citizen, the son or daughter of a U.S. citizen, but you're now 21 or over, right now that's looking like a 6 to 7 year process. Keep in mind that I'm looking at the bulletin, so the National Visa Bulletin, to see where they are, and that allows me to determine the processing time. So the last I checked, it was 6 to 7 years. If you are the son or daughter of a green card holder and you're unmarried, and you're 21 or over, you are looking at 5 to 6 years. Now, here's the good news. For a spouse of a U.S. citizen, green card holder, or the child of a green card holder who is under 21 and unmarried, you're looking at a shorter process right now. That did not used to be the case, but is current. Meaning there's no wait list for the immigrant visa number. That is what takes the longest time. So when it goes to the National Visa Center, you actually, if you're not the immediate relative of a U.S. citizen, that means you're likely going to have to wait for an immigrant visa number to become available. However, the more applications come in, if the applications now outnumber the amount of available the annual limit for the immigrant visa number, it turns into years and years and years worth of a waiting list. And so that is what's happening in most categories. But that wait list has cleared out for spouses and children of green card holders. And so it's current right now, but that will not last. If you don't have a case number or a file number, how can you know your status? So if you don't have a case number or a file, so there is a receipt note number. So usually once your relative petitions for you, they're going to issue a receipt notice, and that's going to have your receipt number while it's being processed in the US. Now, when it gets moved to the National Visa Center, that's where you're assigned a case number. However, keep in mind that if the National Visa Center is not exactly ready to process your case, that could be why you haven't received that yet. So what about married children of U.S. citizens? Thanks for asking, Rudy Love 13. So unfortunately, that does fall further down on the priority list, and that's about 12 years, unfortunately. So it does take a longer, one of the longest times. Now, if a U.S. citizen is filing for a U.S. citizen is filing for their sibling, you're looking at a minimum of 14 years. In the Caribbean, it's a minimum of 14 years. However, keep in mind that it in Mexico, for example, is upwards of 20 years. So keep those questions coming. I am here to answer your U.S. immigration related questions. So put your questions in the comments. So now so far these have all been great questions, and I know that your questions allow me to give you information that you care about. And if you're asking the question, if you have that question in your head, I know that many individuals have the same question. And so your questions are valuable to me because my focus is to give you information that you care about. So keep putting those questions in the comments because I'm here to answer them. Now, let's continue talking about this consular processing. I have been going over who qualifies for consular processing, especially through family. Now, I'm also talking about the length of the waiting time because many people misunderstand and think as soon as that initial petition is approved, then the rest of they get an interview and they automatically get the green card. But that is not the case. Will there be an increase in the green card cap? So if they do choose to have some form of immigration changes or changes in the law, maybe. But right now, the yearly cap remains the same. And so that's why the wait list, that's why the wait list is predictable right now. And that's why it's years long, because you have many more than the yearly annual cap that has been from year to year. How long does it take for a U.S. citizen for parent and siblings? So a U.S. citizen sponsoring a parent is about 18 months. There is a backlog, and that's why it's taking so long. It used to be 9 months to a year, but now you could prepare for a 1.5-year process. And then for siblings, that is the one that's not a quick and easy solution. You are looking at 14 years at minimum if you're in the Caribbean. If you're in Mexico, it's upwards of 20 years. And so it changes from some certain regions of the world, it takes longer. So if a child overstays with a visitor's visa, can she apply for a visa back? Generally, no. So if you've overstayed your visa, you have technically violated the terms of your visa, and so it's no longer valid. And if the child overstays, now here's where it may be possible, but I am just giving you general information because that is a more complex question. And so if you want to talk about your particular case, definitely schedule a consultation. But here's where the child may attempt to apply for a visa. The child would have to leave the United States before they were 18. If they left the United States before they were 18, then that means that they have not accrued unlawful presence. That's the part that causes a lot of individuals to be inadmissible to the United States. Is the fact that they overstay, and if you overstay over 180 days, once you leave the country, you're inadmissible, meaning no visa, no green card, no entry into the United States for at least 3 years. If you overstay over a year, that turns into 10 years. But with a child, that does not happen until the child turns 18 years and 6 months. And so if the child leaves before their 18th birthday, they would not be inadmissible on that basis. However, I don't know the full facts of the case or the situation for the child. I don't know what happened, how did the child get here, and so what kind of visa did they come in with. And so I can only say generally that they wouldn't be inadmissible. However, keep in mind that the visitor's visa is discretionary. So if you're going to the embassy, it is still going to be on record that the child overstayed the terms of the permitted time of that visa. While they're not inadmissible, if it's just a visitor's visa that they're applying for, the officer could use their discretion to deny the visa, just because they now see a history of overstaying, which indicates to them that there's an increased risk of that child overstaying again in the future. So if you need further advice, definitely schedule a consultation. So what forms should my husband file for my child already in the U.S.? So I don't get into forms, Adlam, just because I don't know your situation. I don't know your facts. I don't know, I would not be able, and it would not be fair to you to give you the names of forms without knowing that information, because then you could go and take forms that don't really apply to you or skip forms that do apply to you. And so what I encourage you to do, Adlam, is schedule a consultation and let's talk about your particular details before we get into forms. Kaju, you're welcome. King Pin 92, how long does it take for a U.S. citizen to file for her Caribbean husband? So you could be looking at about 18 months to 24 months. There is a backlog, and so that is why it is taking up to a year and a half. But believe it or not, that is the shortest time. Also, this is general information, right? And so I can give you the estimated processing times just based on my experience and my observations. But one way that you could also gauge it is if you are currently applying already, you can go to uscis.gov, go slide down the page to case processing times, and look for the service center where your application is. And you can look for the I-130 petition that's pending. I'm thinking that's the one that you're applying for. I don't know what other applications you may have pending, but you can see the range of time that is taking to approve that. Now, King Pin 92, if you have not applied already, you want to determine your options. It's always best to get legal advice to avoid mistakes. Can you still file for a visitor's visa while on file? It's maybe possible. It's maybe possible, but keep in mind that once they see an I-130 on record, it's more likely than not that the officer will deny the application based on immigrant intent. Because remember that if someone is filing a permanent residence application for you, that means that you want to come to live in the United States. But if you're going for a visitor's visa, you're basically saying, I promise to come visit the United States and then leave. And so do a temporary visit. While that could definitely be your intention, is not to overstay until your application for permanent residence is actually approved. The officers are more skeptical in cases like that, and they may deny. Now, I have seen it both ways. I've seen individuals get denied because there's a pending I-130, and I've seen individuals get approved even with an I-130, just because maybe the application process, the permanent resident process is decades long. And so it's very unlikely that the person would overstay and complicate their case even further. However, in shorter type cases where a spouse is sponsoring a spouse, or where the petition process is expected to be 18 months to 2 years, then there is a likelihood that it will be denied. Hail Queen Jilly, thanks so much for sharing the live. I appreciate that. If AOS takes only 6 months, is something to be worried about, or is it because the case is straightforward? So Ralu Walia, it's not necessary. It doesn't have to be both, right? I am seeing a pattern where adjustment of statuses have been scheduled within 2 months. And so it could be just a strategy internally where they're trying to clear out the newer cases first. Now, what I would say is don't focus on, oh my gosh, is that a red flag? Focus on why you know that you have a good case, that you have a bona fide case. You can show that your marriage is real. Go in there with confidence with your spouse. Make sure that you prepare for your interview. Talk over your facts. When did you meet? Make sure you know your in-laws. You know your routines. You know which side of the bed you sleep on. You know your routines at work, if anything. How much money is in the bank. Make sure you gather your evidence to show and prove to the officer with confidence that you have a bona fide marriage. And so even if they're booking you early, they're scheduling that because they really want to check out if your marriage is real, guess what? It's real. You know it's real. So go in there and show them. Be prepared. If you are filing and is just waiting on passport to return but got pregnant and have the baby. So Kerry K80, it really depends on who's filing for you. If you had a baby and the baby is, it could get complicated or it could be straightforward. It depends though, who's sponsoring you, what is the status of the person who's sponsoring you, and so forth. For example, if a U.S. citizen is applying for you, so if a U.S. citizen a U.S. citizen spouse is applying for you and you got pregnant with the baby, that baby could actually already be a U.S. citizen. It really depends though on the citizenship status of the parent, the U.S. citizen parent. There are some factors that I would have to look at, but that baby might very well already be a U.S. citizen and you wouldn't have to worry. However, if you are a derivative, meaning you're tagging on along with a parent and you have a baby, then that could be a problem because the baby can't necessarily go along with the derivative. So there can't be a derivative of a derivative. So this is Carrot Cake 80. This is where you definitely need to schedule a consultation. Let's talk about your facts in particular and determine how you need to approach the situation with your baby. And if you did have a baby, congratulations. 2 last questions. Doesn't have to be 2 last questions, Rudy Love. 13, as long as I can get to your questions, I try to answer. So don't be conscious about how many questions you're asking. I appreciate all your questions. So do you work with people outside the US, and will the time frame be shorter with a lawyer? Absolutely. I work with clients all over the world. So I work with clients in all 50 states and across the world. I work with the U.S. embassies all around the world, the National Visa Center, no matter where your case is, immigration courts all over the country, and USCIS offices all over the country. So yes, that's one. Now, two, can a lawyer make the time frame shorter? The lawyer doesn't have an ability to influence the pace of your case. That's the USCIS and their processing times. However, where I can say that an attorney is definitely helpful and can make it faster is where the attorney knows what they're doing. Oftentimes, I find that cases are unnecessarily delayed because this person submitted an application, made many mistakes, and so now there are requests for evidence. Now there's a denial or a notice of intent to deny because something was missing, or at the interview because the application was very shabby. They went to the interview and everything. The officer didn't have a lot of confidence in what they were presenting at the interview, and so an attorney can make it a smoother process and as a result a shorter process because they know what they're doing. And so if you need help, Rudy Love 13, schedule a consultation. My phone lines are open 24/7. So you could call right now. You'll get an after hours receptionist. They would take good care of you and take your information, and then a scheduling coordinator will get back to you on the next business day. Do you handle Canadian immigration as well? So no, I'm only a U.S. immigration attorney. Stepmom is the sponsor and is a U.S. citizen. So Kerry K80, unfortunately, if you are under 21 and unmarried, of course, and your stepmom is applying for you as the stepchild of a U.S. citizen, but stepchild as in you're under 21 and unmarried, you're not allowed to bring your derivatives, meaning your child. Immediate relatives of U.S. citizens are not allowed to have their any dependents come along with them. And so that could definitely be sticky. If your stepmom is applying for you though, and you're over 21, you're unmarried, then your baby would be able to go along with you as long as they're included in the application. I would like to go to America to study. I will go on a student visa after studying. How long can I get my green card? So Juliana Manick, right now, someone on a student visa, actually when you're applying for the student visa, you're also agreeing to go back to your home country after your studies. And so if the officer sees that your intention is otherwise, they could very well deny your student visa. So there is no direct jump from being a student to the green card. However, what happens with some students is they come here, they study, they're very successful in their studies, they get recruited by an employer on an employment-based green card, or even an employment-based green card or a temporary employment visa. And so sometimes there is this natural transition from being a student to being an employee. And then as an employee, you get sponsored by the employer, or you meet someone here and you fall in love. You start a life here with a fellow student or someone that you've met here because you as a student, you're living here and your routines are here. So all of that could be possible. However, there is no timeline that says, if you study for 4 years and finish your degree, you can apply for permanent residence. Or citizenship, you have to be definitely must be a permanent resident. You must have a green card before you can even apply for citizenship. And you must have that green card for 5 years, unless you marry a U.S. citizen, that's 3 years. Can you tell me, can one get an IUL using their EIN? So no, they wouldn't be able to use the EIN. The EIN has nothing to do with immigration benefits. It's usually an employment identification number, and it's not anything that you could use in regards to immigration. So I am going to head over to Instagram because I have a pre-scheduled live there. So Juliana Manik, is it easier to get citizenship in the USA or Canada? So I'm not sure about Canada because I'm not a Canadian immigration attorney. However, one thing I can tell you is you must first find a way to get to permanent residence. Once you become a permanent resident and you have your permanent residence for 5 years generally, or if you're married to a US citizen, 3 years, then you can it's definitely possible to get citizenship. And it's usually the natural process that one goes from green card to citizenship. Now I'm going to head over to Instagram to continue the live there. So this conversation does not have to end here. You can hop on over to Instagram, you can follow me, and then in a minute I will be there to continue this conversation. If you know that you are going to need a consultation, definitely call and schedule a consultation. You can call the numbers on all of my videos. You can also go to the link in my bio. It will take you to the website where you can then call or fill out a contact form, and then a scheduling coordinator will get back to you tomorrow. Tomorrow is Labor Day, but the office will still be open for those of you who are off, and that is your only time to call to schedule. So go ahead and do that. Also, the content I put on Instagram, I put out more content, more videos there that can be very informative. So it can actually answer your question before you even hop on a live with me. You're always welcome to come on and ask questions, of course. So you are welcome to go to Instagram and follow me there, because that is where I do many of my lives here, and I promote my lives in TikTok. However, my content, the actual content that's going to give you important information, along with the lives at 9:30, is on Instagram. So my handle, if you go to the link in my bio, you will click on Instagram button. It'll take you over to Instagram. And my handle is the same as here, The Immigration Attorney. I'm looking forward to seeing you in a minute. If you can't join me in a minute on Instagram, join me tomorrow at 9 p.m. where you can continue to ask your questions. As always, it's been a pleasure, and I really appreciate answering your questions. So keep them coming. I'll see you tomorrow. Bye.